Hi guys, welcome. It's Pegah Rahgozar, your immigration attorney. And as I mentioned, I would be going live this Wednesday for Wednesday Wisdom, where I'll be talking about the latest in immigration laws, any updates in the policies, as well as other immigration topics, and also take any questions that you have already submitted to me or that you'll be asking live on my new Facebook show. I decided I wanted to start this as a opportunity for individuals who have general basic questions about immigration laws or updates, allow them an opportunity to ask their questions, but also kind of give information about the different laws and policies and topics related to immigration, so individuals are better informed in the process. And we've just been seeing a lot of fraud going on in the community, whether it's notaries committing fraud, taking people's money and filing false applications or wrong applications and getting people into trouble, as well as individuals impersonating immigration attorneys. So today's topic, I'll go ahead and dive in. It's going to be about the green card process, and more specifically about marriage-based green card cases filed in the United States. I'll go ahead and talk a little bit about the recent policy update, policy memo with USCIS that went into effect 2 days ago regarding individuals who have to remove the conditions on their permanent resident card. And then at the end of today's talk, I'll go ahead and answer questions that you've already sent me or that you asked live. Before I dive in though, I'd like to just inform you that this is an informational video and it should be used only for informational purposes. It should not be construed as any sort of legal advice. Every case is different and immigration is very fact intensive. So it is highly recommended that you speak with an experienced immigration attorney before filing any sort of application. So we'll go ahead and begin. So you're an individual who entered the United States and are married to a US citizen or a green card holder, and you want to know if you can apply for a green card and stay in the United States. Well, the answer is both yes and no. If you're married to a green card holder, then the wait time generally is 2 years before a visa number is available and you're eligible to get your green card. And a different process, of course, applies for those individuals, which I won't really be discussing in today's video. Today's more about individuals who are married to a US citizen and are considered immediate relatives of US citizens. If you enter the US legally, such as with a visa or with a border crossing card, for example, and you have been inspected and admitted into the United States, generally you're eligible to apply for a green card under the process of adjustment of status in the US. And this is, of course, assuming you have no issues such as past deportation history, that you're not currently in deportation proceedings, that you have not entered illegally, that you have not used false documents, whether presented at the port of entry, or false documents or misrepresentations made to obtain a visa or to an immigration official. So basically, this is for individuals who have a very straightforward, simple case, no issues. Then generally, yes, they can apply for a green card inside the US under the adjustment of status as an immediate relative of a US citizen. The process, as I mentioned, for the adjustment of status, you file the applications. Of course, make sure that you do seek advice in advance. Then you'll generally receive receipt notices after filing within a few weeks. And after that will come your fingerprints and your biometrics. That's when they take your fingerprints and make sure that you are not a threat to national security, that you don't have any issues with your background checks and things like that. Then it takes anywhere from 3 to 6 months on average to receive your work permit and your travel document. And that's assuming you've actually applied for those documents, for those forms, along with your green card application. Each USCIS office across the country handles the process time-wise differently. There is different backlogs at different offices. So some places may be ready to interview spouses for their green card interview within 6 to 8 months, whereas places like Houston, due to the heavy backlog of cases, we're seeing individuals get interview notices a year and a half or 2 years after filing for their green card. When you do attend the interview, which is a very crucial step in the process, it's very important that you are prepared thoroughly for any sort of questions the USCIS officer is going to ask you and any sort of documentation that they will be needing. Once you attend the interview, the officer will make a decision on your case, whether right then and there, or they will tell you that a decision will be mailed to your address. And if you are approved, then you receive a green card. So yay! Of course, the type of green card that you receive will depend on how long you've been married to your spouse on the date that the officer makes their decision, which usually happens to be the date of the interview as well. So if you've been married more than 2 years at the time that the officer makes the approval decision on your case, you will receive a 10-year permanent resident card. However, if you've been married less than 2 years at the time of the interview and your case is approved, then you'll still be considered a permanent resident, of course, but you'll only receive what's called a conditional permanent resident card. And that's actually valid only for 2 years. And prior to the expiration of the 2-year conditional resident card, you have to file to remove the conditions on your card to receive the 10-year green card. Failure to do so within a given window that you're allowed to file to remove the conditions on that card could result in you facing deportation and having to go to immigration court. So you want to be mindful that if you do have a 2-year conditional resident card, be sure that you are aware of when that card expires, and you want to file within the 90-day window before the 2nd year of it expiring to remove the conditions. Now, the USCIS has always issued policy memos on various applications and petition types. And just 2 days ago, they have updated their policy memo regarding the application where you file to remove the conditions on your green card, on your conditional resident card. That form is Form I-751, the petition to remove conditions on your residence. And the recent memo went into effect 2 days ago on December 10th, 2018, and it applies to those applications, the Form I-751, that were filed and received on or after December 10th, 2018. So these new guidelines affect those applications that have been filed, like I said, on that date or after. Just to also inform you that if you did receive your green card through marriage, any qualifying children will also receive green cards through you. Of course, according to immigration laws, any children under the age of 21 years of age are considered children for immigration purposes. And if you are an immediate relative of a U.S. citizen, then those children, of course, will be able to get a green card. And just like you, if you do have to remove the conditions on your resident card, those children who also receive their green card through you, through your marriage, will have to remove their conditions as well. So back to making sure to avoid making sure that you timely file to remove the conditions on your green card. You want to make sure that you file that regardless if you're filing together with your spouse jointly on that petition, or if you're filing by yourself and requesting a waiver. And the waiver request, when you're filing alone without the petitioning spouse, can be usually related to either divorce after receiving your green card. It could be because of death of the petitioning spouse. And it could also be whether you were abused by, if you're abused by the petitioning spouse. So those are the ways you could get I'm sorry, I was having technical difficulties. For some reason, my video froze, so I don't know if you guys heard me. But in order to qualify to remove the conditions on your green card, you could either do so jointly with your spouse, or you can do so on your own through a waiver request. And the reasons for a waiver could be because you've already divorced after receiving your green card, your petitioning spouse has already passed away, or due to abuse by the petitioning spouse. When you do submit the Form I-751 to remove the conditions on your residence, it's very similar to the initial underlying green card in the fact that you must submit sufficient evidence to establish that your marriage was indeed bona fide, that it was a legitimate marriage, not entered for the purposes of fraud or to evade immigration laws. As part of the process for the Form I-751 to remove the conditions on your residence, it's very similar to the initial green card where you have to appear for an interview. This gives the USCIS an opportunity to discover new information, be able to find any relevant information that will help in adjudicating and making a decision on your case. It will allow them to be able to go through your application with you and also determine whether they find you credible. Basically, whether you're lying or you're telling the truth, and that they feel that you have indeed entered into a real bona fide marriage. However, so USCIS, however, has the opportunity to waive the interview requirement and adjudicate and make a decision on that application without having to conduct an interview. And that's what basically this new memo explains, is that the officer in their discretion can review your application in its entirety and decide whether an interview is really required for you. And this could even apply to individuals who are applying on their own and not with their not applying jointly with their petitioning spouse. So the memo explains that 4 things have to be satisfied in order for the officer to waive the interview requirement. Those 4 things, they can basically make, the first one is that they can make a decision based on the record, basically that you have sufficient information, evidence, documentation to prove that your marriage was indeed bona fide and not entered into in order to evade U.S. immigration laws, that it wasn't a fraudulent marriage, basically. The second criteria is that the case would have been received on or after the date of the policy memo that it came into effect, which is December 10th, 2018. So this is going forward with these applications, not ones that have already been previously filed or who have a pending application. This doesn't apply to those individuals. So the second criteria that affects those cases is that the principal petitioner, so your spouse was already interviewed at one point with you, likely in the underlying green card that you received the first time. So if there was an interview the first time around, then that could be part of the discretion that they make in waiving the interview requirement a second time. The third criteria is that there's no indication of fraud or misrepresentation on your application or any supporting documentation that you've provided with that application. And last but not least, that there are no complex facts or issues that require an interview. So an officer feels that your application is complete, your documentation is complete and sufficient for them to make a decision without further interviewing you, and there's no complex issues of fact or law or nothing that requires an interview, then great, they can waive the interview for you and make a decision on the application as it stands. Of course, any case that involves fraud or national security will be referred to the fraud detection and national security director of each local office, according to their local procedures. This policy memo will replace the former June 24, 2005 policy memo, and that one also had revised interview guidelines. So this is the new updated memo that individuals and attorneys will be referring to. This is really for USCIS officers, but it is published for the public to also be able to take into account what the officers will be looking at or criteria that they will be looking at. So that kind of concludes today's topic and discussion on marriage-based green cards and also removing the conditions on your 2-year conditional resident card and the new policy memo that went into effect by USCIS December 10th, 2018, which is 2 days ago. I've already had several questions come in. I noticed some individuals have asked questions, but I'm going to go ahead and ask, or I'm going to go ahead and reference a few questions that have already been sent in to me. So a question came in earlier from Gerardo Campos, and he asked if he needs to renew his passport to be able to enter the U.S. Or like to leave and enter the U.S. if he already has his green card? And the answer is yes. Even though you do have your permanent resident card, you still need your renewed passport in hand with you every time you travel in and outside of the U.S. This will differ, of course, for other individuals, for instance, asylum seekers who later became permanent residents because of their asylum. That's going to differ for those individuals, so you might want to seek legal advice. But generally speaking, for everybody else who's received a green card through a family-based petition or through a work petition, then yes, you do need your passport to be able to travel in and out of the country along with your permanent resident card. Another question came in from Jalaya Caliango. She asked, how long after applying can I get my green card? So that answer actually depends on how you applied for your green card in the first place, whether it was through marriage or is through a family-based petition. That's going to vary in time, whether an interview is required or not. For most cases, even employment cases nowadays do require an interview. The time frame for when the interview, of course, is scheduled will depend, as I mentioned, on how the local office is handling those cases. So some cases may be set for an interview 6 to 8 months, some may take a year, some may take 17 months. It really depends on that local office. Once you go to the interview, generally, if the case is approved or is approvable, then the decision for your green card application and usually the green card itself generally come in 2 to 4 weeks after in the mail. We have another question from Jesus Martinez. He asked that he had applied for a work permit and also applied for adjustment of status, but then was denied. And then he applied for a motion to reopen, which was also denied. Unfortunately, this does not provide me a lot of information, and I'm very limited as to what really happened under your underlying case and why you were denied. You're welcome to reach our office and schedule a consultation so we can dive into the facts of your case and see if this is something that we can help you and figure out where, if any, a mistake was made. I have here Mr. Fayaz Ahmad, and he's asking if I can please explain labor visa, how long it takes, the time and the total cost and all that. So today's topic really is more focused on marriage-based green cards. I can definitely do another Wednesday Wisdom topic where I discuss more of the labor side of things and labor visas, because there's a lot more categories and options and in the process and how, the costs and all that good stuff. So, and of course you had a follow-up question also, is a labor visa a solid way to immigrate to the US? That's really going to depend on a case-by-case basis. So you're welcome to schedule a consultation with our office, and we can discuss ways where you can apply and what your better options are. I have an individual here, Mr. Mehdi and Fossey. I have filed on August 2017 in California office and have not even received a USCIS file number. How long it may take while the process time is 24 months. Did you file a marriage-based case or another type of green card case? You might want to just check with your local office in California. USCIS does publish processing times for every local office based on your application type, and it'll tell you the processing times. You also can go online to the USCIS website and schedule an InfoPass appointment and go into the office and ask a supervisor or a USCIS officer there at one of their windows more specific questions to your case. But that seems like a very specific question to that particular local office. And also, you don't really tell me much about how you actually filed for your green card. So that looks like that is all the questions for today. Thank you so much for joining me today for this Wednesday Wisdom Live, talking about immigration topics and updates in the law. I look forward to speaking with you guys next week, same time, 7 p.m. Central Time, and we'll have a new topic where we'll discuss. Feel free to send in your questions in advance for me to be able to talk to you about. I can only answer general basic questions about immigration laws. Anything that's fact intensive, very specific to your particular case, you're going to have to schedule a phone call or a in-person appointment so we can actually sit down and talk about your case in depth. Thank you so much, and you guys have a wonderful evening. Feel free to reach out to our office at 832-792-3636 if you'd like to schedule an appointment to discuss your case. Thank you so much. You have a wonderful evening. We'll see you next week.